Yes, Mr. McCarthy.
Ali,
I'm Mr. Baldry, sorry. It's the beginning of term, I do.
it's the gremlin that crept in the SDLT decision.
Yes, exactly.
You'll have seen from our skeleton that our position is that the Upper Tribunal decision was right in this matter. The arguments that we've heard canvassed today as to what issues are in the appeal or potentially in the appeal were canvassed before the Upper Tribunal, as indeed before the First-tier Tribunal. And what we say is that the Upper Tribunal properly understood that what this case is really about is the market value of the plot leases. It took into account the issue that was raised in the closure notice, and it took into account the nature of the appeals, and it formed the view that the market value of the plot leases was front and centre of these appeals. And having formed that view, it adopted a course which ensured that issue was dealt with by the appropriate tribunal, the Lands Chamber, but it left open the door to the revenue to raise further arguments and issues, should it wish, by ensuring that that was the only question that was referred, and that the FTT generally had conduct of the appeals on any other issues. But it took the decision to refer the question of valuation because it understood that that was front and centre of these appeals. That is it's either going to be determinative if the matter is an exchange, if the land transaction is an exchange, that's the end of it. Or if it's not an exchange, then the taxpayer's case, and this is the most important feature of this case, is that market value was 30 million according to the valuation that was obtained by the taxpayers at the time of the transaction. They paid 112 million. That overpayment, if it's not an exchange, was an overpayment that has to be explained by the context of the transaction. It was not simply referable to the market value of the land. It was attributable to other commercial factors. So if it's not an exchange, the question will be, was there an overpayment such as to make the excess potentially attributable to other matters? So one only gets into apportionment once you've established the basic fact. What was the market value of the land? So that's why we say, on any view, the tribunal was right, the tribunal was right to hold, that on any view, we've got to deal with this matter. As we said, it's a very basic step of making sure that the correct facts are found before the FTT applies the law to those facts. And that does not involve some incredibly complicated question being referred, which has to be devised by the First-tier Tribunal. To that extent, paragraph 45 is very narrow. We have a debate, which we'll go into, about precisely when the question gets referred, and we say that the Upper Tribunal got those principles quite correct. But the only question that gets referred is the market value of the subject matter of the land transaction. One doesn't have to sort of, well, that's what the Upper Tribunal said should be referred. So that's the only question that paragraph 45 requires the tribunal to refer. And so in the present case, the only land transaction raised in these appeals is the grant of the plot leases. So the question to be referred is the market value of the plot leases. there are some acres in Essex which need to be valued, and the Lands Chamber is the appropriate place to do that. And we see this as the best way of most quickly resolving this issue, because if the revenue are right and that the market value of the land is equal to the price paid, then the exchange argument sort of falls away. It doesn't make any difference. Section 45 would determine the amount of the chargeable consideration. So that would determine it conclusively. But if we're right, and the market value is considerably less, close to the 30 million that we say it is, then that does raise a question. Is there a just and reasonable apportionment to be made between the land, the price that's attributable to the land, or the price that's attributable to other factors? But one needs to work out what the market value of the land is in order to determine this appeal. And that's what the Upper Tribunal understood, and it understood that by having regard to the closure notice and to the appeal. And that's what the First-tier Tribunal didn't do. So, as the Upper Tribunal said, that the starting point is the closure notice, just to be absolutely clear what this appeal is concerned with. It may not be exclusively concerned with that, there may be some other matters, but let's have a look at what this appeal is certainly concerned with. So, you may have looked at that, but if I can just show the closure notice and the appeal, and look at the legislation which governs this appeal, we have that in the supplementary appeal bundle, tab 11, I'll show you the letter that was written shortly before the closure notice was sent into. So the revenue opened inquiries into the provinces that land transactions have been returned on the basis of the lower market value, and Norton Rose explained to the revenue why that was done and why it was an exchange. The revenue then inquired into all matters, including whether there was an exchange or not, and asked various questions about whether it was really an exchange or not, and that was dealt with in correspondence and meetings. On the 27th of September 2012, the revenue confirmed their position on exchange treatment, and so they took advice. HMRC's position under the paragraph headed bold exchange treatment, HMRC's position is that the plot leases should be treated as exchanges for the purpose of section 47, and that SDLT should be calculated on the market value of the land interest transferred by Shell to LG Park HT1 to LG 10 on the 14th of January. That letter was then followed by the formal closure notice, which had statutory effect, and that's at tab 12, 31st of December 2013. The closure notice which closed the inquiries, and revenue are required by the legislation to set out their conclusions and their amendments, and the revenue set out here, the officer sets out her conclusion. As a result of my inquiry, I have concluded that the open market value of this land interest is equal to the 3.7 plot lease premium paid by LG Park HT1 for the land. I have amended your SDLT return to reflect my conclusion. So, crystal clear, we have a conclusion here as to what the open market value of the land interest was, and we have an amendment to the return to take effect of that conclusion. And the taxpayer has a right of appeal against that conclusion. If I can refer you to the authorities bundle. tab 5, revenue entitlement, inquire into the land transaction under paragraph 12 of Schedule 10. That's what they have done. Paragraph 23 at tab 6, page 16. Paragraph 23 is an inquiry under paragraph 12 is completed when Inland Revenue by notice, closure notice, inform the purchaser they have completed their inquiries and state their conclusions. The revenue extraction required to state their conclusions, and the closures must then make amendments of the return required to give effect to their conclusions, and that's what this closure notice does. And then the next tab, 7, page 18, the right of appeal, paragraph 35 of Schedule 10, says that an appeal may be brought against a conclusion stated or amendment made by a closure notice. And you've seen that the notice of appeal, and grounds of appeal in the present case, the appellant has exercised their right of appeal against the conclusion stated in this closure notice that the open market value of this land interest is X amount. So that's why the Upper Tribunal, we say, were correct to say the starting point of this exercise in exercising its decision whether or not to refer the matter to the Lands Tribunal is to look at the closure notice and to determine whether there is an issue that needs to be determined. And front and centre of this appeal, on any reasonable view, as the Upper Tribunal put it, is this closure notice stating expressly what the open market value of the land in question is. And the taxpayer wants to appeal that. And the tribunal with the jurisdiction to deal with this question, which will be appealed against, is the Lands Chamber. And that was the context in which the Upper Tribunal looked at this case, looked at the closure notice, looked at the appeal, and said, formed the view that whatever possible issues might be in play, the open market value of this land is central to this appeal, on any view. So, is it right to send it off now? Well, it set out the principles to be applied under paragraph 45, and we say all those principles are completely right, not that controversial. It exercised its case management powers in the light of this to direct a reference, and it wasn't a complicated thing to do. And so we say that is just the most sensible decision possible, because it gives the one opportunity for complete clarity, and even if it doesn't produce complete clarity, i.e. determines the appeal, it will then provide the basic fact on which the first-tier tribunal can deal with any other issues if they arise. We say they don't arise because it is an exchange, and the revenue aren't entitled to change their mind. But if they are, then all the issues that flow from that will depend on what the market value is. So we just want to get on with it. We've been talking about this for over a decade, and there are no sensible reasons to have a legal proceedings in the FTT with the elephant outside the room, not knowing what the market value of the plot leases are. I mean, what could the FTT properly decide about how attribution would work, or what's properly apportionable to the land transaction or to other transactions, if it doesn't know what the market value of the land is? That's a matter that the Lands Chamber can say. Once it's said what the market value of the land is, then we can have our debate. We say that's the end of it, either because of the closure notice or because it's an exchange. Or if it's not, then we can have question about, well, how much is properly referable to any other interest, and at that stage, if the revenue want to raise their arguments about, well, it's the part you overpaid is referable to another land interest, they can. But we say none of those points are right. But you only get into that argument once you know what the market value of the land is. And that's the conclusion that we've appealed. And we have a right to appeal against that. And so we say the Upper Tribunal were completely right to get on with it. So that's in a nutshell our case. And we say the difference between the Upper Tribunal and the First-tier Tribunal was that the First-tier Tribunal believed it could answer the question about whether to refer or not by reference to the grounds of appeal. And it said, well, because these grounds of appeal potentially raise some other issues, one other issue, then I shouldn't refer. Now, the context in which it made that decision was that it was the revenue's position in the First-tier Tribunal that the FTT could only refer under paragraph 45 once all the other issues have been determined. So the question, the land question, had to be determinative of the appeal. So essentially they were saying that there was no discretion to refer until you have worked out all the other issues. And we say that's wrong. We say that the Upper Tribunal's interpretation of paragraph 45 is correct. Their principles are correct. The Upper Tribunal recognised that paragraph 45 was silent as to when the reference should be made, but they said it's an evaluative process to work out whether this is an issue that falls to be referred at this stage. And
I'm not completely sure that the Upper Tribunal does approach it on that basis. It doesn't just say, look, you've got a free hand. It seems to proceed on the basis that the statute produces a presumption in favour of immediate referral, and that would be wrong, wouldn't it?
In the circumstances of this case, it said that the terms of the closure notice were certainly sufficient to say that, well, the revenue had to come up with some sort of good issue as not to. But their general principles are more neutral than that. They do say they focus on the jurisdictional aspects of paragraph 45. It's in the core bundle.
I mean, if we just, sorry, if I could take you out of your course a moment longer. Paragraph 52. When it's saying why the FTT made an error of law.
Yeah.
The FTT frustrated the purpose and objective. I mean, there seems to be an idea that the statute creates a presumption in favour of immediate referral. Would that be wrong?
Yes, I would say that's wrong. I mean, as I read what their principles, which they say at 40 to 43, they make clear that it is silent as to when the reference should be made. And so when they say that the determination of that question is to be guided by the proceedings, they are making a general point about that the FTT should take into account the fact that the jurisdiction for this issue has been allocated away from the FTT, and it's only that question that needs to be referred. Otherwise, the FTT retains jurisdiction over the appeal. But it's not saying that it has to be.
taking out of your course, but just on terms of those paragraphs, we see three principles in 40, 41, 42. Do they give any guidance at all as to when a referral should take place in circumstances where market value is not the only issue?
They give guidance in the sense that the FTT has got to appreciate that it does not have jurisdiction over this issue, and therefore, if it, and I would suggest that means that only means you then look at it case by case. But if there is a case where, as here, market value is going to be needed to be decided at some time or another, that would weigh strongly in favour of doing it now.
Why? I mean, wouldn't it all, as you say, be turn on the particular facts? I mean, there's no question of the FTT thinking it could decide market value, and it can't. But these matters seem to make that point. There has to be a referral if you're going to address market value, but they don't seem to tell you anything about when the referral should take place.
I think we see how the Upper Tribunal applies those principles by looking at the sort of approach that it took in this case by 48, 49, 50. It started. I think we've got to look at what the issues in the case are to determine whether there is an issue that is required to be referred to the Lands Chamber, and then you have to evaluate, in light of what the issues in the appeal are, whether that reference should be made sooner or later. And because in this case valuation was front and centre of both the closure notice and the appeal against it, on the facts of this case, it was for the party opposing the reference to identify and establish that specific questions in addition to valuation arose in the appeal. So I think all they're saying is that in this case, you just look at the closure notice, and on any reasonable view, this is all about the open market value of these appeals, of this land transaction. So I do not, I read the decision as criticising the FTT, as going the other way, as rather assuming that if there was any prior tax law question, the question should not be referred, which was the revenue's position before the FTT. So I think they're saying that's wrong, and I would strongly support that paragraph 45. I know my learned friend's submission to you this morning was that paragraph 45 talks about the question. So say in sort of very unusual circumstances, the ordinary approach would be not to refer. And so I would say absolutely not. Paragraph 45 talks about where the question in an appeal is a question of the market value of land, then the tribunal shall refer. So we have the question here is the question of market value. It may not be the only question, but it's one of the questions in the appeal. So that's why we say that the Upper Tribunal was right to criticise the FTT for making that, tying it to the prior tax determination as being a reason not to refer was an error of law.
Well, not to refer at the moment.
Not to refer at the moment, yes.
Well, isn't that a case management decision? As long as they understand their obligations at 40, 41, 42, where there's no guidance as to timing, is that not uniquely in the hands of the First-tier Tribunal?
Well, one of the factors, the primary factor was they failed to have regard to the closure notice. The FTT failed to have regard to closure. That's the first, really, the first and the foremost.
Can I understand that one?
Yeah.
I mean, they obviously knew about the closure notice, but they said, well, we don't think it's right to determine the scope of the appeal at this stage.
Yes.
So in what relevant way did they not have regard to the closure notice? You mean they didn't treat it as determinative of the scope of the appeal? Or what didn't they have regard to?
They didn't have regard to it at all. I mean, what the Upper Tribunal said, that the FTT was entitled not to determine the scope, i.e. there were some other issues that the revenue were seeking to raise. The Upper Tribunal said, well, okay, but the First-tier Tribunal did not need to decide those. But nevertheless, you still have to give weight to the terms of the closure notice itself.
Paragraph 36.
Well,
I have to say I'm struggling with that a bit, because if you have decided you're not going to determine the scope of the closure notices, and let's not forget the Upper Tribunal didn't interfere with that part of the decision, then I'm really unclear how you're supposed to have regard to it, whilst bearing in mind that it may well not be determinative.
Because you can look, as perfectly possible, to look at a closure notice, decide or form the view that it clearly does cover this issue, without necessarily deciding that it may also decide other issues.
But if we look at some of the other cases on closure notices, you know, the dispute by the time it gets to court is completely different to the one considered in the closure notice, yet those cases have generally been decided in favour of the revenue's ability to pursue those alternative arguments. Against that context, this may not be a case at all where what's said in the, if the revenue's right, what's said in the closure notice may mean very little. You say it, oh, on any basis it's going to be front and centre, but that excludes the possibility that the decision on the scope of the closure notices really allows you, as the revenue would say they think they're entitled to, ignore the reference to market value. In which case, this isn't just a question of there might be some other issues. It fundamentally affects how you view the scope of the appeal in the closure notices.
I think one has to temper that in this case. What the Upper Tribunal formed its view of was that the market value, which was stated on the face of the closure notice, was going to be an issue at some stage, and no arguments were presented to divert the Upper Tribunal.
But doesn't that rather assume, or to an extent assume, the answer to the prior question, which the UT have said that the FTT were entitled not to determine?
No, I wouldn't say it assumes that, because the Upper Tribunal, or any tribunal, can still look at a closure notice and form a view what is within, what it does contain, and the relevance of that. And all the other putative arguments had been put forward as to what other issues might arise, and none of those issues, market value was relevant to all of those issues. That's why it's front and centre of these appeals, however they're cut. That's even though the Upper Tribunal was prepared not to shut the revenue out on the apportionment issue, and was prepared to allow those to be ventilated or argued about. Nevertheless, in this appeal, you cannot get away from the fact that the closure notice on its face determines the market value, and that the taxpayer has a right of appeal against that determination.
But it does, with respect, seem odd. I mean, when you're working out case management, you surely need to work out the potential issues. Now, plainly, the terms of the closure notice have an impact on the potential issues. But ex hypothesi, they don't necessarily determine all the potential issues. And why, when you're the first-tier tribunal trying to work out what to do, should you say, look, I'll only worry about what's in the closure notice, rather than looking at all the potential issues that need to be decided or may need to be decided?
Well, you have to look at the closure notice.
Absolutely.
In order to determine what issues are to be decided. But in looking at the closure notice, you may well find, as here, that there is one issue at the centre of the appeal that needs to be determined before any of those other issues can be.
And of course you may, but that depends on the view you take of the potential scope of the appeal, the potential issues that are arising. In a particular case, you may say to yourself, look, here, it makes sense to deal with market value first, but why shouldn't you look at all the potential issues rather than just the closure notice?
Because market value will affect all the issues. Market value is the basic question at the heart of this appeal, which will determine what the consideration if there's an exchange or what apportionment should be made. But the argument don't get off the ground until you've worked out market value. That's what you say that's why you have to attach significance to what was in the closure notice and what is within the scope of the appeal, rather than concentrating as the FTT on identifying one other issue which might arise at some future stage, because no one's been able to identify an issue which to which market value isn't relevant.
I thought Ms. McCarthy did rather.
Well, I think
She identifies a particular set of permutations where market value really wouldn't matter at all.
I think that her set of permutations is that the discovery assessments are permitted to be run. That on that basis, part of the consideration which is not attributable to the plot lease, she says, well, it doesn't matter because it's going to be attributable to the release of the MPR.
I think, to be fair, there was another permutation, which is the exchange. The revenue is permitted to run the argument that there is no exchange.
That's her first case. But if there is no exchange, then we're into apportionment. Then one has to work out the chargeable consideration.
We're not necessarily into apportionment, because on the face of it, the leases say if you leave out the options, the leases are just granted for a premium of whatever it is. So, in fact, that's why I keep coming. The first point is the scope of the closure notices, whether the revenue are able to run that argument.
Well, I would say no, because if the market value is the same as the consideration, then the apportionment issues drop away.
No, I'm not here. I wasn't getting as far as apportionment.
But we say that you can't have a sensible discussion about apportionment.
Sorry, I think you misunderstand me. The apportionment point, actually, to be fair, I think was first introduced by the taxpayer. The point, as I understand the revenue to make, is that if they are not tied to the words market value in the closure notices, they're not tied to the exchange analysis, they simply say, well, let's see what the consideration stated in the leases is, and that's the end of it. No apportionment.
But the taxpayer's argument, which needs to be determined, is that if we are outside the world of exchange, then the amount to be attributed to the lease must take into account the market value of the lease. any just and reasonable apportionment
Well,
of the consideration must take into account the market value of the lease.
okay, I won't push it further because we'll get too far into the details of this case. I think I've made my point.
So, standing back from the Upper Tribunal, we've sort of covered the main part of this. Can I just sort of go back to explain why we say that the paragraph 45 is not to be treated as interpreted as it only can be exercised at the time when the First-tier Tribunal has worked out all the other issues.
I don't think it's being said that that's how it should be interpreted.
Good.
I think what is being, and I'll be corrected if I'm wrong about that. I think what's being said is that time is not fed into the terms of paragraph 45, and therefore the issue of when, in all of many different variant factors you can have in these cases, when it's going to be appropriate to transfer under 45 will be a matter for the First-tier Tribunal exercising its case management exercise under the umbrella of the overriding objective.
Well, that's.
I think that's how
happy
it's
to
being
accept that. I thought that my was putting it a little higher, but if it's simply a
She's
question.
not convinced me if she was.
If it's simply a question of there being a discretion for the First-tier Tribunal to refer, then we're happy with that. It's a question of what are the factors that the FTT needs to take into account.
And so what we had here was the FTT, so that's paragraph 36, perhaps, somewhere around there. Yes, I've concluded in order to decide whether it's appropriate to make the reference under paragraph 45, I should consider whether the appeals against the closure notice raise one or more questions that should be decided by the FTT before the remaining question of market valuation can be referred to the Upper Tribunal to determine the appeals. And that seems to me that ties in with what you've accepted would be a discretion available to the FTT.
But I'd say that discretion has to be exercised in the light of the FTT applying its mind to what issues are raised by the closure notice and evaluating in the context of the appeal whether the issue of market value is one that is central to the appeal. And if the FTT does not consider the terms of the closure notice and does not consider therefore the essential question which has been raised by the closure notice and which the taxpayer has the right of appeal against is a question of market value, then the FTT will not have exercised its discretion properly in exactly the way that the Upper Tribunal has held.
Can we just, forgive me if you're going to come on to this, and I think we've touched on it. The FTT looked at the grounds of appeal filed against the closure notice. And as Ms McCarthy said, there will often be situations on appeals where the nature of the issues, or some of them, aren't apparent from the closure notice. And essentially what my understanding of the relevant ground of appeal is the taxpayer saying, well, we can explain the 116, it's for other things. What is wrong in the FTT having a look at that? You're saying really you should just, I may have misunderstood you. I think you're getting the sense you're saying just look at the closure notice, end of. But the notice of appeal sets out the sort of an element of the framework of what the dispute is actually going to be about when it gets to the tribunal. So what was the FTT doing wrong there?
Well, I would say that the scope of the appeal by looking at anything else other than the closure notice. The closure notice and the background to it is the document which sets out the scope of the appeal. So if somebody raises another issue in their closure notice, that's by the by. But in the present case, I would say that our grounds of appeal were directed foursquare at the issue of market value. That's the only thing we were dealing with.
It is your notice of appeal, or that the relevant ground of appeal, is part of your explanation as to why it's wrong to look at the 116 as a proxy for market value, and that seems to me directly to challenge the closure notice, which effectively is saying we think 116 is a good proxy for market value. So it's not as if your notice of appeal, you're not saying your notice of appeal is sort of not directed at the closure notice. It seems to me it was.
It was, but what the I think what the FTT took is that issue of apportionment that we raised in the context of market value, which was the issue raised by the closure notice, could also be relevant to an issue which is raised by the revenue, which on the face of it is outside the scope of the closure notice, namely that this is not an exchange, and therefore the consideration is the amount you've actually paid, the cash. I think. So our grounds of appeal were solely concerned with market value, but that issue of apportionment, should the revenue be permitted to argue for an exchange?
Sorry, I think we're getting well.
There are two types of apportionment.
I think that's right, and I think the risk is being. All I'm getting at is that you're putting in as part of the grounds for dispute. We can explain the 116. It's nothing to do with the market value of the land. It's because there are other things going on. I'm not looking at this in terms of apportionment or anything like that. But does that not raise by itself, whether you call it a technical apportionment issue or whatever, it raises issues which Mr. McCarthy is saying should be determined by the FTT.
No, I would say not, because
okay.
the issue raised by the closure notice is market value. That is the only conclusion stated in the closure notice. So if we raise an argument as to why market value is 30, in support of our argument that the market value is 30, that's only going to the issue of market value. So it would take some other step to be taken by the revenue to expand the scope of the appeal away from what's plainly stated in the closure notice. But the point that the Upper Tribunal understood was whatever potential arguments do arise, they still all flow from what the actual market value of the property is. So that's why I see it like this is the first fact to be found. Yeah. The task of the FTT is to apply the law to the facts, and so to have a hearing before the FTT dealing with all these procedural issues and legal arguments and potential appeals going all the way up back to this court again before establishing that primary fact seems to be an absurd potential waste of time and money. Work out what the market value of the plot leases are. That can be done in a relatively straightforward appeal to the land we'll know where we are. And it may be that that's determinative. It may be that if it's not determinative, if it's not an exchange, then the list will know what the basis on which we're arguing, whether there should be any just and reasonable apportionment of the 112 to something other than the plot leases. Because if it's the market value is found to be 112, then our argument in 6B of the notice of ground falls away, and so do all issues of apportionment. But that's why we're seeking this reference in order to give us the best chance to determine this issue which we've been arguing about since.
Can I try a slightly different direction? I mean, by the time of the FTT hearing, the discovery assessments hadn't been raised. By the time we got to the Upper Tribunal, they had been, and of course they have been for us as well. And the FTT has said, well, it makes sense to deal with all these appeals together. Am I right in thinking that the discovery assessment appeals potentially give rise to a question of the market value of the release of the shell option?
Well, we don't see that as happening because it's not an exchange. The reason why there's the subject matter of the plot leases
yes, I've
is determined by market values because of section 40.
I follow. So how do you determine the value of the release of that option?
Well, I think the revenue say everything, we say nothing. So there isn't a market value question at all.
When you say the revenue say everything, you mean everything but the market value of the leases?
Yes, I mean, what we would only be talking about, anything, once you've determined the market value of the plot leases, then there would be, on our case, an excess that was paid for those plot leases that should be attributed on a just and reasonable basis to other factors. Now, the revenue say, well, if that's right, then what that has to be attributed to is the plot leases.
Now,
you don't mean plot leases?
MPR.
Yes, MPR.
yes, I follow. So you say no question as to the value can arise from the discovery appeals, the discovery assessment appeals. But it's sort of the same question that arises on closure notice appeals, is it? How you would split between the value of the leases themselves and the value of the release of the option.
We would say that the starting point for any debate whatsoever about whether the release of the option is a land transaction for which chargeable consideration can be given is whether part of the consideration paid for the plot leases was excessive, so can be attributed to that release of the MPR.
I mean, you could look at it the other way round. You could say, well, when you're working out the value of the leases, you need to work out the value of the release of the option.
Well, that would be so rather making the tail wag the dog, because this is an argument that the revenues have come up with. But we say that the MPR option isn't a chargeable interest at all. It's just a contractual right. There isn't any.
I think, Mr. Baldry, it's not entirely fair to say the revenue came up with that, looking at the history of the correspondence, but just to stop Ms. McCarthy's jumping up and saying something else.
But I think you would say anyway that to approach it in that way would be completely to avoid the commercial reality as has been described in the papers, that at the end of the day you were engaged in this ferociously expensive arbitration that seemed to everyone was completely stuck in.
Yeah.
And at the end of the day a deal was done and everybody knew that it was vastly inflated over what would be the normal market value of these 10 plots. But it was the deal that was done in order to secure what the taxpayer desperately wanted, which was out of the option.
Indeed, yeah.
And Shell that was what Shell was prepared to take in order to release it.
Yeah. So it is very much in the context of that transaction, which that's why market value has become front and centre of these appeals, and we say the Upper Tribunal was right to form the view that at some stage this has to be determined, and it was right to say that the appropriate course was to do it sooner rather than later, because the Upper Tribunal, that will then provide the certainty for any other issues to be canvassed again. That's just the cheapest way, in monetary terms, of coming to a solution that may avoid these other issues. But if they don't, I mean, it's much more likely that the tribunal would have to have a sort of preliminary hearing to work out sort of, certain issues. Then it goes to which produces appeals. Then it goes to the land tribunal after all that's been sorted out. Then we work out what the market value of the land is. Then, inevitably, there'll be a further question about what do we do with that. So, if we work out the facts first, that's going to be the best solution.
Now, I apologise, we've taken you grossly out of order, out of turn, but you've been extremely helpful and patient, so we let you get back on track.
Well, not at all, because actually, I mean, in one way or another...
Yeah, your case is your case, isn't it? This is about market value. The obvious thing to do is to determine that. There's a procedure to do it by way of paragraph 45. The FTT should have ordered that to happen. Upper Tribunal put them right, and that's the position.
Yeah, and that is our case. The other way we put it, and if that's right, then that's the end of it. The other way that we did put it was by reference to the closure notice and the scope of the closure notice. In a sense, all the cases on the scope of the closure notice, which I know that the court will be familiar with, are relevant to the first issue as well, and just in determining in order to determine what is front and centre of this case, what do you look at? So we do have to look at the closure notice, but we do say that the Upper Tribunal would have been entitled to say that the FTT had erred in law by not deciding the closure notice point, because the FTT effectively said that it was not going to refer the question of the market value of the land because it had jurisdiction over other issues. And that's exactly what the FTT said. And we said, well, the FTT can't, that must be an error of law. If the FTT had concluded that it wasn't going to look at the closure notice, and so not decide what issues it had jurisdiction over, it was wrong for it to have refrained from making a reference because it had jurisdiction over other issues. So we say in not deciding the scope of the closure notice and deciding to make the reference in those circumstances, the FTT erred in law.
Does that amount to saying it has to decide the scope?
It has to decide it before it can refuse to. It can't. Well, it can't refuse to decide to refer the case for the reasons it gave because it had jurisdiction over other issues.
So if it didn't feel it had enough information to decide the scope of the closure notices, I think you're saying if it was minded to refuse to refer otherwise, it should have gone through the hoops of deciding the scope of the closure notices.
Yes.
But that leads you potentially to a much more lengthy, detailed preliminary hearing than the sort of case management hearing that was actually heard by the FTT. You say not, but we're told that even before the FTT they didn't have the full inquiry correspondence.
But no one has suggested what relevant documents were omitted. I mean, we put forward we put forward what we consider to be the primary documents, and because the terms of the closure notice in the present case were so clear, and because the revenues express agreement that there was an exchange immediately preceded the closure notice, we said, well, this was a clear case, and so that and that remains our case if it ever goes to the FTT after we've been to the Lands Tribunal. Our case is, well, now that market value has been determined, that's it. That's the only thing that is within the scope of the jurisdiction of the FTT. And you're quite right, when you read the cases, there are precious few where taxpayers have succeeded in confining the revenue to something that was written in the closure. But all the cases are cases where the revenue had come to some conclusion, such as this loss should be disallowed, and there's either been correspondence or something like that. There's nothing remotely comparable. You go to Tower Cashback, and it is said that the revenue should, if they can, issue closure notices with precise terms, and if the point is short, that should be stated on the closure notice. And here, the conclusion stated on the closure notice is so precise, so clear, and the amendment that is made is the amendment that gives effect to that statement conclusion in the closure notice. We say that the tribunal should have dealt with that.
Is it of any potential significance on your case that it was only, if I've got this right, after the closure notice that you said, oh look, a lot of this is attributable to the release of the shell option, and moreover, that isn't within the scope of SDLT because it's exempt?
Well, I'd say two things about that. First of all, yes, it's correct that any precise arguments that take place as part of negotiations between the parties after a closure notice has been issued is irrelevant to the construing the closure notice, completely irrelevant. But I also make the point that the DP World wrote to the revenue both before and after the closure notice was issued, making the basic point that the price paid was representative of other issues, not simply the land. There's a letter at tab 13 of the supplementary appeal bundle. Corresponding between the parties carried on after the closure notice was 31st of December 2013. On the 28th of October 2013, on page 126, the DP World have been negotiating with the revenue. So they explained in my letter dated 30th of May 2013, the price paid of 112.8 is represented as a number of factors, not merely the value of the subject property. So,
well, and it refers to the MPR.
Indeed, yes, moving guard.
Can I just raise one point? Sorry to interrupt, but when you say that arguments following the closure notice are irrelevant, I'm not sure that any of the case law has really considered two things. First of all, the situation where the correspondence carries on and develops significantly following the issue of the closure notices. Secondly, although I think it was the case in Investec, it's not really discussed, we now have this very formal review process. And the appeal is referred to the tribunal after the review. And I referred to the review earlier, and I pointed out I didn't think we all had all the relevant provisions. Now, this may not matter much, but it just seems to me that we do not have any definitive case law on whether that sort of process makes any difference. So since Town Cashback and a number of the other cases were decided, there is this formal review process that can be gone through before an appeal goes to the tribunal. That was gone through and results in a formal review letter, and it's only following that, and that letter's in the core bundle, it's only following that there's a reference to the tribunal. I'm not suggesting this is the case, but I'm just conscious that the previous cases don't really debate whether that makes any difference. In other words, do you end up looking at things that are not just the closure notice? I just wanted to flag that.
Well, I'd say two things about that. First of all, that from the case law that we do have on closure notices, we do have very clear authoritative statements approved by the House of Lords in terms of cashback, Supreme Court, in terms of cashback, that the scope of the appeal is defined by the conclusions stated in the closure.
Indeed. But just to put it out there, I'm not suggesting this is right, but we all know that one looks at the context, and in those cases, context was determined by what was said in the inquiry. But under the regime we now have, matters continued between the taxpayer and the revenue for some period, including formal review process and a detailed review letter. And I just wanted to raise that I don't think there's been any real consideration of whether that potentially makes a difference to the sorts of things you look at to determine what the scope of the FTT said appeal
yes,
is.
My answer to that would be that the review procedure cannot alter.
Yeah,
the matter
I
the
thought
matter
you'd
in
say
question.
that. I thought you'd say that. I just wanted to flag it
Yes.
as a point that I don't think's been decided.
That's true, and your ladyship was right to point out we didn't have the
I think it's
exact
36G.
36G. But if one looks at the same language is used. So if there's a notification to the tribunal without having gone through the review procedure, then the tribunal is to decide the matter in question. And the matter in question in all these provisions, whether it's 36A or 36G, is the matter to which an appeal relates. And therefore the matter to which an appeal relates is the matter that's defined by the closure notice. And so because 36G4 also requires the tribunal, after the review procedure, to decide the matter in question, it can't be of any wider scope.
Yes, but it also, standing back, I've just raised the question whether it would be a sensible result for a court always to simply disregard effectively everything that's happened since the closure notice in determining what the dispute is about.
Well, I think it would be very, very dangerous, because in correspondence after the closure notice, the parties may enter into all sorts of negotiations and arguments as to how they best put it into effect. But I would submit that all that is relevant under the system that we do have, that the closure notice is supposed to give finality as part of the procedure. And the idea that in SDLT, a closure notice should have some lesser effect as suggested by the revenue
Sorry, it's not my point is not limited to SDLT
No,
because
exactly.
obviously this procedure has been
I was dealing
introduced.
with,
Yeah, but that's a separate point. Yeah.
But yes, but I would say that arguments that that the parties raise in correspondence or in statements of case or whatever stage cannot affect the scope of the appeal, which is defined by the closure notice. What you do see is the courts being prepared to consider the closure notice in context, i.e., looking backwards to see what the taxpayer reasonably understood from the closure notice, and so that's either in the context of determining what the conclusions are. So if the conclusion is more broadly worded, but there have been other matters in canvas between the parties leading up to that, then the mere fact that the revenue have not articulated one of those matters that they've been talking about in the inquiry period doesn't make a difference. But where there, and the Investec case was an example where that didn't happen in relation to the conclusion, but the revenue sent a closure notice that had alternative amendments to it, and so they're entitled to do that. But that's a long way away from a closure notice as here, where it is completely focused on one specific issue, and the amendment gives effect to that one specific issue. And if any statement that we would say would be relevant beyond that is the fact that the revenue expressly agreed that it wasn't exchanged before sending out the closure notice. And the closure notice is written on the basis of market value, and the only basis on which market value could possibly be relevant in this context is if there is an exchange. That's the only relevant statutory provision which engages market value.
Could you just tell me, I've got the letter, the view of the matter letter from August 2018. Could you just remind me which tab number the actual review that is requested?
It's in the core bundle.
That would be why I couldn't find it.
Yes, it's in.
Sort of expecting it to be follow on from the view of the matter letter.
Yes, it's page 147, I think.
Ah. Michael, was the my index? That's it. My index only goes up to. So page 147.
Yes.
Thank you very much.
And that's there, is it? Because I see the notice of appeal refers to the review conclusion letter.
Yes.
143.
That's the formal process by which the matter is notified to the tribunal.
Yes.
But my submission is that process does not affect the closure notice and therefore the scope of the appeal.
Yes. Now, where have you got to when we keep promising to leave you in peace and fail to do so?
Most of the tricky points on our respondents' notice has been canvassed in the course of that. We sort of summarised the principles to be applied in our skeleton argument. And my learned friend took the point, well, we can't just sort of raise this point, but we say it is engaged because it provides an alternative reason for the Upper Tribunal to reach the decision it did, in the sense of it's consistent with the reference being made. But we say that the Upper Tribunal was perfectly entitled to adopt the halfway house that it adopted. It was entitled to say, well, I'm not going to decide the closure notice point in the sense that I'm not going to definitively rule out at this stage these other points that the revenue are saying could be raised, but saying that nevertheless they don't seem to produce any reason for not dealing with the valuation point now, because that's going to be the key point to be decided. And so, in taking that approach, we say the Upper Tribunal is entitled and right to do that.
Can I just pursue my red herring one moment, just so I'm clear in my own mind? Get reverting to something you were explaining earlier. So, as regards the release of the MPR call option, you say, well, it's exempt. If so, there's, the discovery assessments don't go anywhere.
But I think it's a little bit more nuanced than that, because we say actually, first of all, that, as my lady said, that the overpayment was part of this sort of commercial arbitrage with Shell, needed to break the chain with Shell. So the NPR, the release of the NPR was a part of that, and that's what the evidence goes to. If it does.
Yes, I see.
But then we say, even suppose that you did overpay for the lease, some amount is attributable to the MPR option. Our first one was that's not a chargeable interest at all. It was just a contractual right in lieu of damages for Shell at that stage to have an option, but it didn't have an option before then. It was not a right that sort of ran with the land or anything. It was a sort of personal contractual right. So no chargeable interest at all. If we're wrong on that, then those issues of security interest are pretty far down the line.
I follow.
Thank you.
So as you say, there are various hurdles that have to be jumped before you get to any question of valuation at all.
Yeah.
Just suppose, for the sake of argument, that HMRC clear those hurdles.
Yes.
So it turns out that there is a chargeable transaction.
Yeah.
I think you were saying earlier you'd still attribute nil to it, would you?
Well, there are two points there. We say that we attribute nil to it, but even if the revenue were able to say that some amount should be attributed to it, we still need to work out what amount. The revenue, so where it doesn't matter, that just means everything's taxable. So we don't need to work out market value. But this was part of the friend's confusion of saying, well, they're just the taxpayers.
Yes.
But they're not. Even if you've got to the stage of saying that an amount has to be apportioned to the NPR option, the purchaser of that option would be Port, LG Port being the company that benefited from the release of that option. So that's a different taxpayer, not one of these appellants, but that is an appellant in the discovery assessment. So
just pursuing it a moment longer.
Yeah.
There are obviously lots of hurdles. Just suppose somehow all those hurdles are cleared, so that you have to work out what, if any, value to attribute to the release of the option, which, as I understand it, you say was paid for, albeit as part of a wider commercial picture, through the premiums that were paid for the leases. On what basis would you go about valuing the release of the option?
Well, once you've worked out the amount, you wouldn't be necessarily valuing the release of the option. You'd be attributing that's how much of it.
So you would be deciding how much of the totality of the 116 million was attributable to the release of the option.
Yes, it's not a statutory question like
No.
the exchange rule. The exchange rule says that the market value of the subject matter is the chargeable consideration. We don't have anything like that. It would just be how much is attributable. But you would need to find out to get down that route. You would still need.
That takes you right back to the beginning of your
Yeah.
because you say that the figure that my lord is looking for is the difference between the market value of the properties as determined by the Land Chamber, subtracted from 116.
And you can't just say, well, it doesn't matter because it's all taxable, because you've got to work out which taxpayer is liable for which bit.
Yes, I see.
Thank you.
Well, unless I can assist you further, I think in a roundabout way we've covered the submissions.
Excuse me a moment.
Can I just clarify what your position is on the respondent's notice? Because
Yes.
you've not focused your submissions on it. I would like to understand a bit better what your position is.
Yeah, our position is that for the reasons sort of set out in our skeleton as to why the scope of this appeal is confined to the closure notice as stated, we say that that provided the Upper Tribunal with an alternative way of dealing with the appeal. The Upper Tribunal could have said to itself, the First-tier Tribunal erred in law in refusing to make the reference of the question on the basis that it had jurisdiction over other matters. That's what the FTT concludes. Paragraph 42.
So you maintain the arguments put in your skeleton?
Maintain the argument, and I haven't been, the authorities are quite well known, well understood, and principles I rely on a site there.
Yes.
What we say is that applying those principles, that if you read the closure, you've got to construe the closure notice and what it would mean to the recipient.
Yes.
That on specific terms of this closure notice is of such crystal clarity that the scope of this appeal is confined solely to the open market value of the plot leases. It follows from that there are no other issues within the jurisdiction of the FTT, so that the FTT was wrong to conclude that paragraph 42 that because there is at least one other question within the jurisdiction of and to be addressed by the FTT, before it would be appropriate to refer evaluation questions to the Upper Tribunal.
I can't remember the detail. My impression was that the FTT decided that this wasn't the right time to determine the scope of the appeal. And does not your respondent's notice require you to impugn that case management decision?
Well, I'm seeking to uphold the Upper Tribunal's decision on an alternative ground.
In that sense, you're seeking to impugn the Upper Tribunal's view that it couldn't impugn what the FTT had done. But if we go back to the FTT stage, you have to find that you can impugn their case management decision that this is not the right time to decide the point. Is that right?
Well, I would say that what the FTT couldn't do is not decide the point and then exercise its discretion not to refer on the basis that there were matters still within its jurisdiction, which is really saying he should have decided the point. But
it assumes the answer to the first question by assuming there are other points within its jurisdiction.
Yeah.
Well, okay.
On the FTT's approach, there was at least one question outstanding, which was the scope of the appeal, which they put off.
I think that's not really an issue. That's just what are the issues. But I think the one other question was the question of apportionment was the one that the FTT had in mind. They said, well, that is an issue that I still have jurisdiction over because I haven't decided I don't need to have jurisdiction over it. But we say no, that's an error of law. And looking at 42, I remind myself I haven't dealt with the overriding objective point, but we say that the overriding objective can't be disentangled from the other reasoning. The tribunals go through the reasoning, which states their powers, whether they can or they won't, and then sort of cross-check is this within the overriding objective.
You say the overriding objective can't be used as a cloak to cover up errors of law.
No, you can't just say you need to get the law right first.
Anything else? Anything else? Thank you very much indeed, Ms. Ward. Anything in reply?
Yes, if I may, there are just two themes that I want to cover briefly in reply. The first theme is, if I can call it, the chicken or egg theme, which has come up in my learned friend's submissions, which is what comes first, determining market value, then everything else falls away, or determining the contract price and what that contract price was paid for. And the way my learned friend put it in his submissions is, he said at one point, if there's no exchange, then the overpayment has to be explained. So what he's considering there is, if there's no exchange, so we're interested in the contract price, what was the consideration given? On his analysis, he says, well, the market value is only 30, yet the contract price is 116. There has to be some explanation as to why that is. But analytically, that's wrong, because if there's no exchange, it doesn't matter whether or not the taxpayers have overpaid for the land, because if there's no exchange, the contract price is the consideration given, and that's the end of it. And my learned friend started to, I think, misrecord our route to market value being irrelevant on the hypothesis that there's no exchange. I'm not going to repeat that route because it's captured in the transcript. But what he did was he said, oh, well, at some point, even on that route, you have to determine what is a just and reasonable apportionment. But remembering the just and reasonable apportionment legislation, that is only engaged if consideration is paid for more than one thing, more than one asset. Take the example of the arbitration that your ladyship referred to. What has gone on here? Is it, in order to settle the arbitration, the taxpayer agreed to pay 116 for land, or is it the taxpayer agreed to pay 30 for land and the balance to settle the arbitration? And that's the difference between, was the 116 for one asset, just land, or for more than one asset, more than one thing? Land, settling the arbitration, this MPR release. If it's the former case, then whether or not the taxpayer overpaid for land simply doesn't come into the analytical, the SDLT analysis at all, because it's simply the contract price. Now, when my learned friend says that we have to know the market value in order to work out what the proper contract attribution should be, that puts the cart before the horse, because it's a matter of simply disentangling the deal, interpreting the contracts, and that will tell you precisely what that 116 was paid for. Knowing the separate question of market value won't help with that contractual interpretation, because as I've just explained, there are two ways of doing a deal, taking the arbitration account. Either I want all this to go away, I'll give you 116 for your land, or here's some money for land, here's some money to settle the arbitration. And the Lands Chamber can't work out that dispute. That is simply a matter of fact-finding for the first two. It isn't a matter of market value. So we say that that demonstrates that market value can't be first, it can't be central. Rather, the starting point is to work out what that contract price was apparently paid for, and that's a pure matter of contract interpretation. If, as a matter of looking at the contracts, you come to the conclusion that 116 was only paid for the land, just and reasonable apportionment isn't engaged at all, because you've got one price for one thing. There is simply no just and reasonable apportionment exercise. Now, the taxpayers at that point may like to say, oh, but we overpaid for the land. SDLT legislation is not interested in that. SDLT legislation is simply interested in the cash that was handed over. So that's why we say analytically market value can't come first. There was also, I think at one point, and I apologise if I've misrecorded my learned friend's submission, but I think my learned friend also suggested that the exchange question didn't arise on the discovery assessment appeals, which is concerned with the release of the MPR option. We simply don't understand how that analytically can be correct, because on the analysis, certainly that has been floated at one point by the taxpayers, Shell got 116 million plus 2 options as part of that clause 2 deal. Question, what is it that the taxpayers got in return for those 2 things? Was it just the plot leases, in which case, for all the reasons given, market value may never come into this, or was it plot leases and MPR release? And we don't understand analytically how it can possibly be said that if those are the assets on either side you're weighing up, the question of exchange doesn't come into the discovery assessment appeals at all, because that makes no sense to us. Because either 116 plus these 2 options were paid for land, or on one of the alternative permutations, they were paid for land plus MPR release, and we don't understand how you disaggregate the 2. My learned friend, and as the last part of the market value point, my learned friend took the court briefly to, it was the letter, I think it was from DP World, 28th of October 2013, and that's tab 13, PDF page 126, and showed the court some paragraph in that letter before the closure notices where this idea of the existence of the MPR option and the release was mooted. But again, to be clear, in that letter, the MPR option was not, this is a separate asset which attracts part of the 116. It was simply, this is a commercial reason as to why we, DP World, the taxpayers, were prepared to overpay for the land. And it's really important to understand that those 2 different formulations are separate, are distinct. And it's for the first tier to work out on the facts what the actual issue is. The reason it's for the first tier is because my learned friend says, oh, market value is part of the evidence as to attribution. No, that's wrong. Who paid how much and for what asset is a pure contractual interpretation point. Actually, the contract price, what in real life did you pay for this asset, is part of the evidence of the subsequent market value dispute. That's the way round it is. So he's wrong in principle to suggest that market value is evidence of attribution. No, the attribution question and the contract price paid is part of the evidence, especially here as it's between unconnected parties, is part of the evidence that the Upper Tribunal Lands Chamber will then consider when it works out whether or not it's representative of market value and what market value is.
And you say that it's not for the Land Chamber to do the job of working out what that contract
Exactly.
is for.
Not least because that attribution is contractual interpretation. Contractual interpretation is a point of law, and the Upper Tribunal Lands Chamber only has jurisdiction in relation to a separate factual question: what is the market value? And that's why it's so important to be clear about what is being said. Is it simply, we paid too much for land? Because if that's the argument, you do get to a stage where, depending on the outcome of the closure notice appeals, no one cares about market value. Or is it actually that price paid was for two separate assets? And it's pushing the cart before the horse to say, oh, market value somehow unlocks all of this. It doesn't, because it's important to recognise what is evidence or part of the relevant background for what dispute. Market value cannot answer the question of contractual interpretation. That brings me on to the next theme, and I just wanted to make a short point about the closure notice, the scope of the closure notice, the respondent's notice, and all that dispute. Just picking up on a couple of points that arose in the questions to my learned friend. Point number one, we would say, well, the taxpayers just haven't overcome the hurdle that gets them through the gateway to look at the respondent's notice question. But on any view, my lady asked a question relating to the matter in question language that appears in the legislation. That language does appear and was considered in Investec. That language doesn't appear in the earlier cases, for example, Tower or Fidex or so on. And we say that that matter in question language, when you read that part of Investec, is part of the reasoning where the Court of Appeal comes to the conclusion that the scope of the closure notice is more than the words written on the face of the closure notice. So my learned friend can say, and we've looked at the closure notice, oh, well, look, HMRC have typed onto that piece of paper market value. The market value is, therefore, the SDLT is. Investec tells us definitively that those typed words do not answer the scope of the closure notice question in law. The point that's also important to note about why that must be right, the scope of the closure notice is broader than the words the revenue have typed out, is, put the question this way, scope of the closure notice is not about a case management decision denying the revenue the chance to bring back new arguments. It's in fact about the first tier's jurisdiction on an appeal. What is the first tier allowed to decide? If it is the case that the scope of the closure notice in this case is market value and market value alone, and it's not broader than that, then looking at what happened after the closure notice was issued, the taxpayers said, we the taxpayers actually want to raise this brand new point, which is not just about market value, it's the brand new point that that contract price was actually paid for two things. If it is right that the scope of the closure notice is limited to market value, and that defines and limits the first tier's jurisdiction on an appeal, it must logically follow that the taxpayers can't raise those arguments. How can that possibly be right? That just can't make sense. It cannot be the case that HMRC, depending on what precisely they've typed in a closure notice, can somehow block a taxpayer for raising alternative arguments. So we say, well, what's sauce for the goose is what's sauce for the gander, because it's not about fairness, it's about jurisdiction. That's the scope of the closure notice point. And that's why we say that when the discussion in Investec is properly understood, in particular, the issues that the Court of Appeal allowed in Investec concerned the underlying partnership transactions, but contrary to my learned friend, they did not form either part of the closure notice or part of the amendment. They were actually in a side covering letter. Investec is determinative. The very words you type in the document called the closure notice does not determine the scope of the appeal. If those words determine the scope of the appeal, then what's in a covering letter, which is not the conclusion and not the amendment, is neither here nor there. And I think, if I can just have 1 moment, please. Those are all the submissions I wanted to make.
Thank you. I think the transcripts were being obtained by your side, were they not? I wonder if we could have copies in due course, please.
Certainly.
Thank you very much. Well, thank you all very much indeed, both, of course, the leaders, but also everyone sitting behind you. I know that much of the hard work has been done by both the juniors and the instructing solicitors and members of their firm. Thank you for your submissions in this important and complicated case. And we're very grateful for both the written material and the oral submissions we've heard today. You won't be astounded to hear that we're going to reserve our judgments. We will aim to get them with you as quickly as possible, but make no promises, although you may benefit from the fact that it's towards the beginning of term, so you'll be high up the list. The drafts will be sent out in the normal way for typographical errors and other infelicities, and not an opportunity to re-argue the case, please. If there's any outstanding matters, we'll deal with them in writing, and we'd hope that ultimately you'll be able to agree in order between you. May I remind you, I think everyone's getting used to it now, but the stringent terms of the embargo that now appear on the top of the draft judgments, they must be taken at face value. I know it can sometimes be difficult. I don't think it's normally the leaders that have to deal with this. I suspect it's usually the instructing solicitors that have to try and explain to their lay clients and half their boards and half the tax office that they're not entitled until the judgment is handed down to see the draft. So please ensure that the rule requiring us to have a list of who's going to see the draft judgment is complied with. Unless there's anything else that we can help anyone with today. Okay. Thank you all very much, and thank you again for sitting early.
Court rise, if able.